Please be seated. Court now calls case CV140588, Michael Russo versus Stephen Barger et al. This is the time set for oral argument. Counsel, you both have 20 minutes to present your oral argument. Counsel for appellant, you can reserve time for rebuttal. Just let us know. Keep track of the time on the podium in front of you. Please keep in mind that these proceedings are audio and video recorded, and they'll be uploaded to our website. So there'd be, basically something on YouTube if someone wanted to search it about your presentation today. We have read everything in the case. We've read the briefs. We're familiar with the record. So keep that in mind as you make your presentation. And when you first step up to the podium, if you would, state your name and your client. We'd just like to double check here to make sure that we have the right counsel representing the right party.
We want to make sure we're in the right chairs.
We want to make sure that we're in the right chairs, which didn't happen the last time. Counsel.
Thank you, Your Honor. Good morning. My name is M. Philip Escolar of the Escolar Law Office, and I represent Mr. Michael Russo, who is the plaintiff and appellant in this case. And even in light, if I may begin, even in light of I should mention, I will attempt to reserve 2 minutes, if possible, for rebuttal. I understand it's my responsibility to keep track of time, and I'll do my best to do so. And I noted that the court had mentioned that it had reviewed the briefs and is familiar with the facts. That said, if I may still attempt to spend a minute or so briefly reviewing the record, I think that's important because this appeal, this case, essentially turns on the record,
well,
so to speak.
What part of the record would be helpful to us is for you to elucidate us on what transpired between the answer that asserted the forum selection clause and the motion 3 years later. What happened in that period? Because I think that is very relevant.
Very good, Your Honor. Thank you. In our opening brief on page 18, we essentially list a laundry list of specific acts that took place. Generally speaking, we had a complaint filed in the middle of 2009, a timely filed answer. The answer did invoke the forum selection clause, I believe right at the outset in the first paragraph. But since that time, and that would have been around July or August of 2009, what essentially transpired was intense discovery and disclosure. Both sides issued numerous disclosure statements, numerous discovery requests. 4 depositions were taken, but primarily on the motion side, a motion for partial summary judgment was filed by the plaintiff. And in response to that, the defendants filed a cross motion for summary judgment. And then they each filed their responses and replies with respect to their individual motions for summary judgment. The trial judge reviewed the the motions, and then decided that it would be necessary to also do some supplemental briefing on a particular issue, happened to be statute of limitations. The supplemental briefing was done, oral argument took place, and in the end, the trial judge denied both motions for summary judgment.
And as I recall the record, not only is it Judge Gama?
It was Judge Gama, Your Honor.
Denied the motions, but he also ruled substantively on the tolling issue, didn't he?
I believe he did. With respect to this, I also believe in his minute entry he did state that the defendants could raise the statute of limitations again at trial, but that he felt for the purposes of summary judgment, viewing the facts.
And I'm looking at his ruling where he says that the facts support an equitable tolling of the applicable statute of limitations from certain dates through the dates your client discovered the non-existence of the, quote, force majeure ruling. So he at least found for purposes of summary judgment sufficient facts had been alleged to deny a statute of limitations defense as a matter of law.
That's correct, Your Honor. And after that took place, a supervening event occurred after the filing of the complaint. The Arizona Department of Real Estate suspended the public report of the developer, Worldwide Group. It suspended it due to non-delivery of certain units in the prior public report, the amended public report. It promised delivery by a certain date of units. The delivery didn't occur, and the ADRE unilaterally, based on several complaints, I presume, yanked the public report, so to speak, and put it in a suspended status. That led the plaintiff to amend the complaint as to Worldwide Group. It didn't add any additional claims or facts helpful with respect to the appellees that are present today, but with respect to one party, Worldwide Group, it actually brought up another cause of action. Thus, the complaint was amended in October of 2011, and that is where both parties seem to agree the case suddenly languished, so to speak. The defendants, through their prior counsel, suddenly stopped participating, more or less. The prior attorney, John Politan, withdrew from the case in early 2012. The trial court set a status conference to try and figure out what was going on, and by that time, the defendants had split. Worldwide Group obtained counsel from Tucson, and the Barger and Michigan defendants at that time, March 2012 or so, did not have any counsel.
And there was a default, and then it got set aside and all that.
Very good.
But let me ask you this, because what you're saying raises a point the answering brief makes, which the answering brief tries to draw a distinction between the conduct of these appellees, the Michigans and the Bargers, and the other defendants, kind of saying, well, we were just on the coattails. But does the record support that any of the filings that occurred during the 3-year period were just on behalf of the other defendants, or were the Michigans and the Bargers part and parcel of every filing that Worldwide made during that 3-year period?
None were ever specifically made with respect to one individual defendant or another. They were done as a group. An omnibus, I believe, is what Mr. Politan referred to it as when he filed it, an omnibus filing covering all defendants. And
Cross motion for summary judgment, I know that at least 2 of the counts were only against Worldwide, but one of the counts that all of the defendants sought summary judgment on was specifically against these appellees. Is that correct?
that is correct, Your Honor. And while the counsel for the appellees does mention that the cross motion appears to just be simply shoehorned in as a 2-paragraph addition to the response to our summary judgment motion, it essentially incorporates the full 15-page response and uses it offensively to seek summary judgment. And if you look at the cross motion, or excuse me, the response to our summary judgment motion, it includes very specific facts to these appellees that attempt to exonerate them with respect to charges that we have, that we leveled against them in the complaint, such as consumer fraud, and whether business was transacted in Arizona in violation of the subdivision public report statutes and so forth. That said, we don't believe they can say they've only lightly touched the forum, but they literally attempted to achieve factual exoneration, and not just on the statute of limitations. If you look at their response, and for that matter, their reply, which also attempted to exceed page limitations, they were very voluminous responses and replies. They pled very specific facts specific to the Barger and Michigan defendants. That said, this wasn't a battle between Mr. Russo and WWG, and the Michigan and Barger defendants were simply floating on the coattails behind them. They pled specific facts and argued specific facts for their own exoneration. That is right in the primary summary judgment filings.
And why is that important to the forum selection clause?
Well, we think in some of the case law, and some of it was brought up by the appellee in their answering brief, it does seem to suggest that there is some sort of threshold of participation at the lower level, at the original trial court, some threshold or level that if you exceed it, you have waived then the forum selection clause. One example would be, I think a good one would be perhaps the Taylor case, where cited by the appellee, where right after a plaintiff files a complaint, the defendant immediately moves for dismissal based on the forum selection clause and does a couple, I guess you could call them peripheral filings in support, though, of that motion to dismiss. And then the plaintiff states, oh, well, now you've waived your right to invoke the forum selection clause because you're participating in litigation with something other than a motion to dismiss. The trial court disagreed and said they're just essentially lightly touching the forum. So I believe Appellee is trying to create a theory where, despite seeking complete exoneration on the merits, they are only lightly touching the forum.
I don't know. Also asserting that it's a factual question, and Fields does suggest that that waiver can be and often is a factual question. What about here?
Here, the very extensive record, we think, especially with respect to the summary judgment motion and the context of it, and I think I noted when I discussed Fields in the reply, and I may have quoted a court that said, but it can appear as a matter of law from the record whether or not waiver has occurred. But generally it is a question of fact, yes.
I think you mentioned 4 depositions. Were any of the did the depositions involve the Michigans or the Bargers?
Mr. Michigan's deposition was taken.
How about Mr. Russo?
Mr. Russo's deposition was taken twice.
So,
and an employee of Abigail.
Was that 2 of the 4?
That was 2 of the 4. 2 were Mr. Russo's deposition, Mr. Michigan's was the 3rd, and the 4th was an employee of Abigail.
Now, what bearing, if any, in your judgment, does it have that the forum selection clause was raised in the Bargers and Michigan's answer?
Very little, and I believe case law, such as the Fields case, which is strikingly similar, I think, to our facts, in some respects at least, where the city invoked it was a notice of claim issue. The city invoked the notice of claim issue in its answer, but then did nothing to pursue it over years. I believe 4 years was the case in the Fields case. And then the city attempted to invoke it in a summary judgment or other dispositive motion 4 years later, and the trial court found in Fields that just invoking it that's great, and so presumably as long as you do something with respect to pursuing it in a diligent manner, that's fine. But in Fields, they didn't do that. They simply invoked it, did nothing with respect to it until 4 years later, and then invoked it, and the trial court found waiver. We believe that is essentially what has happened here.
Would the same situation apply if somebody invoked or referenced an arbitration provision in their answer, and then for 3 or 4 years acted inconsistently with invoking that arbitration clause?
I certainly feel that way. In fact, I think the arbitration jurisprudence is very relevant here. Arbitration clauses are a species of forum selection clause. It just happens to have a state statute and a federal statute that urges essentially enforcement of that clause. Other than that, they're essentially forum selection clauses, and the jurisprudence with respect to that is very clear, including in our own state, that if you attempt to seek redress, for instance, that you could achieve in the arbitral forum, and you attempt to achieve it in the trial court, you've waived it regardless of what's in an answer. And I believe that was our Bolo case here in Arizona. And that is what happened here. They attempted to seek ultimate exoneration. And, I'm sorry.
No, that's okay. Have you noticed that the quality of my question is superior to Judge Gamel's questions?
But inferior.
I have. I have not. 2-1. Okay.
Don't answer.
Of course, Your Honor.
That's a way to interrupt an argument.
And regarding arbitration in particular, I believe I've cited very many instances, and all you have to do is replace arbitration with forum selection, and I think these holdings and the principles behind these holdings apply.
Are there cases? I gather we don't have an Arizona case on the forum selection clause and waiver of it.
I don't believe we have one, Your Honor, that essentially tracks or would be helpful with respect to the facts of this case.
And then moving from Arizona outside the state, my next question is: are there strong cases one way or the other, or are the cases mixed nationwide, or are there not very many?
Well, certainly, and I believe this court would know this well, over the last 20, 25 years, arbitration has gone from being somewhat disfavored in the forum selection.
I meant to focus this on forum selection.
Strictly on forum selection.
Please.
I believe we've cited a good number of those, Your Honor, and
Any particular one or two that you are most fond of?
Sure. I appreciate the chance to.
I know there was a lot of discussion about other cases dealing with the enforceability of the forum selection clause, but that's not our issue. And both Judge Gama and I think to some extent the answering brief went into some depth about that issue. And we're not here to decide whether it's a valid and enforceable clause. We're here to decide whether it was waived, correct?
That's correct, Your Honor. And we never made a contest down below or here for that matter with respect to whether we were challenging the validity of the clause itself through the Moosex test, so to speak.
But that's where I remember you talking about the other jurisdiction forum selection clause cases. I don't remember you citing cases dealing with waiver of a forum selection clause from other jurisdictions, though I could be wrong. And also, if you want to look, you could tell us on rebuttal. But I thought the foreign cases mainly dealt with the validity and enforcement.
And I will take a quick look, Your Honor, as I pause prior to rebuttal to see if I did cite one specifically in the context of waiver,
yes,
as opposed to.
That's what I was getting at.
Thank you, Your Honor.
Yeah, thank you.
And, and I suppose, even though no one really brought it up other than me, or I should say the plaintiff and appellant, is that Campbell rule, where.
Well, Judge Gama kind of went off on that tangent without citing that proposition, but the answering brief didn't raise it, and we're not in the habit of going into issues that the parties don't raise on appeal. So you can talk about it if you want, but I think you'll muddy the waters.
I'll go ahead and decline at this time, Your Honor, to speak about that issue. And noting, unless the court has further questions for me at this time, I will reserve time for rebuttal.
Thank you, counsel.
Thank you, Your Honor.
All right, counsel for appellees.
Thank you. Good morning, Your Honors. Mary Hone on behalf of the appellees, the Barger and the Michigan defendants. I would like to focus the court's attention on the Arizona Supreme Court case of City of Phoenix versus Fields. As the court mentioned, the defense in that case was not forum selection clause, but it was a personal jurisdiction defense, or the waiver of that defense in the form of the notice of claim statute. And the Arizona Supreme Court did specifically state the rule that is applicable in this case, and that was the waiver of the defense should be found when the defendant has litigated the merits of the claim by taking substantial action that would not have been necessary had the defendant promptly raised the defense. And that is what the plaintiff is arguing in this case, that we didn't do it fast enough, we didn't do it soon enough. But the Arizona Supreme Court case of Fields was based on, they found that the defendant had waived their right to claim the notice of claim statute based on 4 very specific actions. They said that after the filing of the answer, the initial answer, the defendants there engaged in extensive briefing regarding class certification. Second, after class certification, they filed various motions, including several motions for partial summary judgment. Third, the defendant public entities engaged in discovery after class certification, including submission of Rule 26.1 disclosures that did not disclose the defense of the notice of claim statute. And fourth, the motion for summary judgment in that case that finally raised the applicable defense was filed more than 4 years after the complaint was filed. But that's not the facts of this case. The issue is the same, the rule is the same, the analysis is the same, but the facts are very different. And waiver of the defense should not be found in this case because the Barger and Michigan defendants have not litigated the merits of the claim through substantial action that would not have been necessary had they promptly raised the defense.
Well, let me challenge you a little bit there, because we do have 3 years of a whole lot of activity, including, and I'm going to quote from a stipulated order that the parties signed, and I know you weren't counsel at the time, and you're stuck with what happened for 3 years when you weren't on the case, so I appreciate that. But In a stipulated filing, the parties said that vast amounts of discovery and disclosure have already taken place, including written discovery requests, responses, and multiple depositions. That they were asking for a revised scheduling order. And then your clients did move for summary judgment on the merits as to one of the counts against them. I get that it's not exactly the same as the conduct in Fields, but we have 3 years of a lot of court filings, a lot of discovery, a lot of disclosure, and it seems like that's a problem.
Your Honor, my clients were not involved in the discovery, the disclosure, the depositions.
Well, but you can't say that from the record.
I can say that from the record.
Don't interrupt me. Let me finish. Mr. Politan, every filing that he made was attorneys for defendants. He never differentiated between the defendants. And so every filing that was made by the defendants, and there are many, I've counted them during that 3-year period, is attributable to your clients based on the record. There's nothing in the record that would allow us to say, oh, well, he was only talking about Worldwide or Abigail or Las Palomas. It's just not supported by the record. What in the record would allow us to say none of that involved your clients?
Okay, specifically, Your Honor, if you would look at the motion for summary judgment that was filed by the plaintiff, it takes up numbers 31 to, 47 of the record, and that, what it says, every single line says, against defendant Worldwide Group. That motion was against defendant Worldwide Group, and it was filed 9 months after the case was filed.
That's Mr. Russo's motion, right?
Correct. Then,
wait, we're going to have difficulty. Let me just finish my thought. He's seeking partial summary judgment against Worldwide, and then in response, your clients, I recognize it's only on one count as against them, but they affirmatively seek a judgment as a matter of law on the merits of count 5 against them. And they make arguments, including that Mr. Russo did not rely on Mr. Mishkin's representations about the force majeure ruling. They argued that they had never marketed the condo. They never solicited Russo. So they affirmatively sought a judgment as a matter of law on the merits. And then when they lost, asserted forum selection clause.
Your Honor, my clients, the Bargers and the Mishkins, the only thing from in the record that shows that they were participating is that Alan Mishkin signed the affidavit in support of the cross motion for summary, or in support of the response to the motion for summary judgment. And there's no evidence in here that they took. There's no evidence in the record here that depositions were taken. There was, except that.
Of the 4 that he mentioned, there's absolutely evidence of that in the record, and including statements by the parties in a stipulation they filed with the court setting forth each of those 4 depositions that had been taken.
With respect to my clients, Mishkin and Barger, the deposition that was taken of Michael Rousseau. And those defendants, the defendants' counsel took the deposition of Michael Rousseau to support the response to the motion for summary judgment. So that is in the record that involves my clients. I understand that, but.
And Mr. Mishkin was deposed, and that's in the record.
You're referring to the stipulation that you.
It's several places in the parties' filings that enumerate the 4 depositions that have been taken, including Mr. Mishkin's.
Your Honors, it is the Bargers and the Mishkins. They were riding the coattails of the Worldwide Group, and a lot of the time, although the court refers to 3 years of litigation, of course, a lot of the time was spent. The motion for summary judgment took over a year to decide, to brief and decide, and it was slow going. In the meantime, my clients weren't involved. They weren't paying. They weren't doing anything. They didn't know anything that was going on, which is why counsel.
That in the record. Where do we have that they weren't paying? Where do we have that they had no idea what was going on? Where do we have that in the record?
They're not mentioned.
They are mentioned when we have a motion for summary judgment as to, quote, all defendants. And we have filings on behalf of all defendants.
The 2-paragraph response to motion for summary judgment does say all defendants, yes. And it references the response that was written to for Worldwide Group. It doesn't specifically say the Bargers and the Mishkins. It says all the defendants. And but my point is, Your Honor, that you have to look at in the Arizona Supreme Court case of Fields, there were some definite actions that the public entities took. That's not the same as my clients. They didn't. They weren't filing motions. I understand that John Politan said defendants, but he wasn't. Well, never mind.
Does it have any bearing in your judgment on the question of waiver that your clients did raise in their initial answer, as I understand it, the forum selection clause?
They did raise it, Your Honor, and
matter on waiver.
Yes, well, it's a threshold issue. Sure. If they hadn't raised it, I don't think we would be here today.
They would have waived it right then.
Sure. But they didn't waive it, and
waiver later, does it matter? Yeah, I guess it provides a foundation for this argument.
Right. That's the question before the court today, is whether my client's actions do rise to the level of a waiver. And
is there, excuse me for interrupting again, but is there anything in the record as to why the forum selection clause wasn't asserted aggressively prior to the time it was?
Or asserted at all, I guess.
No, Your Honors, there isn't anything in the record that would indicate why. But the test.
We would love to ask you why, but if it's not in the record, we can't. We don't want to know, really. So.
The test, though, is whether the. Oh shoot! I lost my train of thought.
I'm sorry. I did that to you. Probably.
That's okay. Whether it's in the record. The participation in the litigation, that's the test. That's the test that's going to be applied to the acts that my clients took. And it's whether there was substantial action taken that would not have been taken otherwise. And in this case, that 2-paragraph motion for summary judgment that was written in response to the plaintiff's motion for summary judgment, it would have been written and the depositions would have been taken regardless of whether they added this one issue of jurisdiction. So my point is, there wasn't a bunch of litigation that was taken and then my clients hop in there and say, wait, there's no jurisdiction because of the forum selection clause. My clients got involved when Mr. Politan withdrew and Worldwide Group found their own counsel. At that point, then they found out they were defaulted and they had to get counsel and jump in there and get going on it. So that's what happened. And
you know, it used to be that if a party, and now I'm in the context of notice of change of judge, if a party goes before a judge and the judge rules on something substantively, a substantive issue, a motion, or a discovery dispute, or something like that, then neither side can notice that judge after that. Well, in this case, you know, by analogy, in this case, the judge did make some rulings. Some motions were denied, motions were asserted and denied. Why isn't that, by analogy, a waiver of the right to say, oh, we don't want this judge, we don't want this forum? They didn't say that until they got some, one could say, they didn't say that until they got some adverse rulings.
Because you have to separate the defendants. My clients were riding the coattails of Worldwide Group, and this motion, the substantive motion that was filed against the defendants, was filed specifically against the Worldwide Group. If it had not been filed against the Worldwide Group 9 months after the complaint was filed, perhaps the jurisdictional issue would have been raised. I don't know. We don't have those facts before us.
Don't you think, counsel, in some ways this is really worse than Fields? Because in Fields you're talking about a notice of claim defense, which really the notice of claim is to kind of advise the government entity about what the nature of the claim is and so forth. Where here you have an actual forum selection clause that would take the case right out of the court, just like a mandatory arbitration provision. In some ways, it seems to me this is the type of defense that really has to be promptly asserted, just like a mandatory arbitration clause. Can you speak to that at all?
I don't think it's any worse than the Fields case, Your Honor. I think it's on a par with the Fields case, but I think our facts are better than that, and that this court can find the opposite of what the Supreme Court found in that case. I do think that that if the court looks at the record, that my clients weren't in there asserting anything. They were responding to the motion filed against them by the Worldwide Group, and then counsel, of course, tacks on the 2-paragraph response or the motion for cross motion for summary judgment. So no, I don't think that it's worse than the Fields, and I think that this court can find on this record that these defendants did assert the jurisdictional question as soon as they had the chance.
What about the arbitration cases? It seems to me in the arbitration cases, waiver was found with far less action than was taken in this case. Can you speak to that at all?
I don't think the arbitration cases add anything to the analysis that we have here, because we have the Arizona Supreme Court case of Fields that is directly on point. The only difference in that case is that the defense was a notice of claim defense rather than the personal jurisdiction defense. But I think the analysis is precisely the same, and that given the facts of this case, it's not as egregious as what happened in the Fields case. We don't have the same specific steps, specific filings that were taken, that were made in the Fields case that were done in this case. With respect to the Bargers and the Michigans, I think in June 2012, when they set aside the default and then filed their motion to dismiss in response to the amended complaint, was the first time that they had to assert this defense and to really get it before the court. And of course, it was successful. So I do urge this court to affirm what Judge Gama did and to find on the same facts and the same law that he had before him that the motion to dismiss was proper, and that based on the forum selection clause, which was negotiated and signed, that the contract should be fought in Mexico. Thank you.
Thank you, counsel. Counsel?
I suppose the first thing I should do, Your Honor, is confess that it appears in my opening and reply brief, I do not have a specific Arizona or out-of-jurisdiction case that I cite to involving forum selection clauses and waiver.
I don't think there is one in Arizona, but
I wish I could say there just aren't any, but I'm sure the clerks sitting here would.
Well, Taylor is. Taylor is.
Taylor
is a waiver issue of a forum selection clause, but for the reasons you stated, it's substantially different, because Taylor, at the first opportunity, the defendant filed a motion to dismiss based on the forum selection clause, and then later opposed a motion to amend, saying, hey, you shouldn't rule on the motion to amend because we have a motion to dismiss based on forum selection clause. So, so there, we do have that one waiver case.
And I suppose one other in rebuttal here thing I'd like to add is there's a theory here presented by counsel that that there was diligence on the part of the Bargers and the Michigans in bringing up this defense because they brought it up at their first reasonable opportunity, and that Mr. Russo's motion for summary judgment essentially got in the way. And it did take a year and some odd months before it was finally ruled on. The interesting thing about that, though, in the cross motion as it was set up, there was apparently time and thought putting into asserting a statute of limitations defense. It seems like that was the perfect opportunity to bring up forum selection. And I don't know of any law or any principle that would preclude bringing up the form selection clause in a motion for summary judgment, at least on that particular issue. And that said, it seems like they missed an opportunity. In fact, to be honest, looking at the record, it looks like they never missed an opportunity to miss an opportunity. 3 years. They didn't file it until defaulted and separate counsel was obtained. That said, Your Honor, we believe the trial court unfortunately erred as a matter of law, and that the decision should be overturned and sent down.
Anything else? Thank you, counsel.
Thank you, Your Honor.
Counsel, we appreciate your arguments. We'll take this matter under advisement, and we will issue a written decision in due course. Court is now in recess.